Skyways Limited was an airline that operated from after the Second World War until the early 1960s. For a while, it was a very substantial player in the new commercial aviation industry, but by the early 1960s, it was in trouble. The company decided to make a substantial portion of its workforce redundant. Captain Edwards was a pilot offered a redundancy. The terms of the redundancy were for 3 months' notice, the return of all his contributions to the company's pension fund, and an ex gratia payment, equivalent to the company's contributions to the pension fund. Ex gratia means by favour. It is a term used when someone makes a payment without accepting any legal obligation to do so. So the company was essentially saying, if we make you redundant, we will pay you this amount of money, but we're doing it out of the goodness of our hearts and not due to any legal obligation. Captain Edwards accepted the redundancy, but then the company changed its policy and decided not to pay. When he demanded the payment, the company responded that it was an ex gratia payment, and so he had no right to demand it. Now, there was no question that a promise had been made, and there was no question that Captain Edwards gave consideration for the promise by accepting the redundancy. The question was whether the agreement was enforceable, or whether the words ex gratia made it an agreement in honour only. Justice Migor said, "The words ex gratia, or without admission of liability, are used simply to indicate that the party agreeing to pay does not admit any pre-existing liability on his part. But he is certainly not seeking to preclude the legal enforceability of the settlement itself by describing the contemplated payment as ex gratia." The court said that an agreement like this, a commercial agreement, would be presumed to be enforceable. Justice Migor said, "In the present case, the subject matter of the agreement is business relations, not social or domestic matters. In a case of this nature, the onus is on the party who asserts that no legal effect was intended, and the onus is a heavy one. Our starting position then should be that any agreement in a business context which meets the requirements for contract formation is enforceable, unless there is clear evidence to the contrary."